Those that haven't been able to attend because of the weather, we will have a recorded version available. Let me first thank you for joining our first California-specific webinar. We are the law firm of Conn Maciel Carey. We are a new employment and workplace safety specific law firm. We are a national law firm with offices on the East and West Coast. I am a partner heading up the California office. During this call, everyone who is online will be muted so we don't have any background noise. And I will leave time for questions at the very end. And any questions you do have, you can ask on the chat line, or you could send an email to me, and I'll make sure to answer them. Any questions I can't answer today, I can always answer after today's call. Today is an interesting topic, particularly because we've had such an active legislature and governor in California this past year. In years past, we haven't had quite so many employment laws. And this year, having a Democratic legislature and Democratic governor, we've had over 20 new laws on employment issues that have gone into effect this year. The laws range from paid sick leave to a number of other issues, some that may be less significant for your business, but we'll touch on very briefly at least. There was a time when we did not have quite so many employment laws year to year in California, particularly when Arnold Schwarzenegger was governor. And this year, it is a different situation. So I think this is a good time to go over the new laws. This will be also an important time to revise practices and employee handbooks. Let's just begin briefly by introducing me. I'm a partner with Conn Maciel Carey. My practice involves employment-related counseling on handbook issues, discipline, reductions in force, leaves of absence, issues like that, as well as representing employers in a variety of sorts of employment-related litigation. Now, the agenda for today will involve three different areas. One is this latest wave of over 20 new California employment laws. The focus will be primarily on the paid sick leave law that is causing employers a great degree of consternation here in California, as well as just giving a refresher on the minimum wage laws in California. There have been a number of local ordinances that have gone into effect this past year. And then lastly, just touching on the new local employment laws in San Francisco, Los Angeles, and Oakland, and how that may impact you. Okay, so the major California employment laws, except where indicated, they all go into effect January 1st of next year. And the first one is the California paid sick leave. That's AB 1522. And that is legislation that is patterned after San Francisco's paid sick leave law, which, as many of you know that who do business in San Francisco, that went into effect back in 2007 and has required significant changes in leave policies. And the California legislature has followed suit and enacted a paid sick leave law that is patterned after San Francisco, but is in many ways quite different in its provisions. In terms of eligibility, all employers in California are required to comply with this order. Includes private employers and public employers. It also covers all employees, including temporary and part-time employees. And in terms of what employees are covered, You may have employees that work in different states, might come to California for a period of time. The legislation states that any employee who works at least 30 days within a year in California is subject to this ordinance. Now, what is within a year in California? The Labor Commissioner has provided guidance recently, very informal guidance, but that that 1 year measure is basically from January 1, 2015 onward. And if an employee is hired after January 1, it's the end. So typically you're going to be, except for grandfathered in employees, you're going to start with the anniversary date, and then each year look at whether this employee has been in California working at least 30 days a year. There are certain exceptions or exemptions to this leave law. One is for any employee that's covered by a valid collective bargaining agreement that provides for wages, hours, and working conditions of employees, provides for paid sick leave, and includes an arbitration provision. And there's also an exemption for employees in the construction industry that are subject to a valid CBA. There is also an exemption for any provider of in-home support services to the aged, blind, or disabled. And lastly, there's an exemption for the airline industry for certain types of employees. Now, the first major issue under this ordinance is the accrual. This law provides for the accrual of 1 hour for every 30 hours worked. And the accrual begins on July 1st, not January 1st. So there are certain obligations that an employer has to begin complying as of January 1st. But then on July 1st is when the actual accrual begins. Some employers may want to begin the accrual January 1st as they revise their handbook for ease of process. But in terms of the accrual, for non-exempt employees, the 30 hours worked will include essentially all hours, and the law is not clear on what is included and what isn't included, but based on the lack of detail, it's safe to assume that that would include overtime hours worked as well. And for exempt employees, you will typically consider them to have worked 40 hours a week. That you can base your calculation for determining the accrual. All right, so moving to the next slide, there's two types of calculations for accrual. And this provides much needed flexibility for employers. There's the accrual and the lump sum method. The accrual essentially allows the employee to accrue a certain amount of paid leave, and as we discussed before, that 1 hour for every 30 hours worked, and that accrual can carry over from year to year, and that is a certain quirk in this new law. But the employers have certain options here. One is that they may limit the use of paid sick 24 hours or 3 days in a year of employment. They also cap the total accrual at 6 days or 48 hours. Now, what is the year for the purposes of determining the year of employment and how it would carry over? Based on guidance from the Labor Commissioner, it appears that time frame would be that you start on July 1st when the law takes effect, and then you go forward a year. However, if an employee is hired after that date, you would base it on the anniversary date. So, for example, if you have an employee that, if you have a group of employees right now and you implement your policy on July 1st, you would take the first year for the accrual to be July 1st through the end of the next year. And you would allow an accrual through that year period and allow carryovers thereafter. However, if you decide that you want to implement this policy January 1st, one means of calculating this, there is no guidance from the Labor Commissioner, but it seems reasonable, would be to start on January 1st and have that be your effective year, with the exception that as employees are hired, their year would be from the anniversary. Now, the other method for providing this paid sick leave is the lump sum or the upfront method. That is a means for the employer to provide a certain allocation upfront at the beginning of the year. So the employee would be allocated 24 hours or 3 days of paid sick leave during any year as defined by the employer. So that could be a calendar year. That could be based on the anniversary year. It seems for many employers that it would be much more convenient and easier to administrate to have that year based on the calendar year. And so the employee is allocated that amount of paid sick leave that they can use throughout the year. This will provide some benefits, the lump sum method, for employers, because they do not need to be tracking the accrual, and they can essentially just give this leave up front for the employee to use throughout the year. Now, in terms of the permitted use of paid sick leave, there are three different categories. One is this paid sick leave can be used for the diagnosis, care, or treatment of the existing employee or defined family member. The law does not define what a health condition is. I think we can consider that to be a fairly broad construction. And in terms of the family member is defined in the law as a child, spouse, domestic partner, parent, grandparent, grandchild, or sibling. And the second category of permitted use is preventive care of the employee or a defined family member. The last category is time off for an employee who's a victim of domestic violence, sexual assault, or stalking. The third category is related to a leave statute that we have in California that provides time off for those categories. Now, this ordinance, or this law, excuse me, presents some frustrations for employers that are doing business in San Francisco or Oakland, where they have their own paid sick leave laws, because the law states that this provides minimum requirements and does not affect other laws providing greater accrual or use by employees. So that means if you're in San Francisco or Oakland, you must comply with not only the California law, but also San Francisco Oakland law. Now, the problem with that is the laws are not the same, and there are a number of conflicting terms of these different laws. And what is key in terms of implementing is to make sure that you comply with the version of the law that is most favorable to the employee. There are some instances where it's difficult to really determine which is more favorable, and that will really require some weighing. And in San Francisco, just as a backdrop, and I'm going to go back to that slide one more. It's important to note that the cap is different in San Francisco, 72-hour cap on paid sick leave than employer. Also in San Francisco, the rate of pay for paying out sick leave includes overtime, whereas that is not the case in California. And San Francisco is fairly clear on the type of documentation that an employer may require for employees to take absences using paid sick leave. Specifically in San Francisco, any absence of 3 days or fewer days deemed unreasonable for the employer to ask for medical documentation. So let's discuss the quirks to this new California sick pay law. One is that the employer may set reasonable minimum increments of hours or more for use. So that means that the employer could require employees to take the sick pay in 2-hour increments, 3 hour, 4 hours, 5 hours. Another quirk is that the employee may only use this accrued paid sick leave after the 90th day of employment. So there's this essentially probationary period before an employee may use the sick pay. It is important to note as we're discussing all of these aspects of the paid sick leave law that an employer can, of course, provide greater benefits if they would like. And they can have their own PTO policy or another version as long as they comply essentially with the California paid sick leave, its minimum requirements. In terms of paying out sick leave, an employee is or the employer is required to pay the employee for paid sick leave at the next payroll period after the sick leave is taken. And for the purpose of paying that out, just a regular hourly employee, the calculation will be pretty straightforward. You just take the regular rate. However, if you have an employee that's earning commissions, then you need to factor those commissions in the calculation. Also, if you have an employee that has different rates of pay, you need to average those rates of pay. There is a guideline in the law that essentially requires the employer to look back 90 days for calculating the hourly rate where there's commissions or different rates of pay. The one favorable aspect of the new law is that it does not require that employers cash out sick pay on termination, whereas PTO and vacation, as a matter of law in California, must be cashed out. And there is one unique aspect of this new law, is that if an employee separates from the company and is rehired within 1 year, any accrued unused sick pay must be reinstated. And so essentially, you're going back and figuring out what was left at that time and putting it back on the books. Now, there's a number of notice requirements under the California paid sick leave law. And these all take effect January 1st. One is, those of you that do business in California are aware of the wage theft notice that goes out or is issued to employees upon hire. That form has been updated by the Division of Labor Standards Enforcement, the DLSE, and that form is available on the DLSE's website. And that form must be provided to all of your California employees as of January 1st with the additional information required under this California sick pay law. Further, you must notify non-exempt employees any change to information in that notice within 7 calendar days of that change. Alternatively, you may provide that notice of the change in a timely wage statement. The other requirement is that there's notice of the amount of available paid sick leave when wages are paid. So you'll want to make sure that on your itemized wage statement you have a category for the available paid sick leave. There's also a posting requirement, and as with other California laws, there's a requirement that you have a poster in a conspicuous place in the workplace, in this case in all workplaces that you have in California with these requirements. California Chamber of Commerce has to post separate notices to the laws. Okay, so in closing, what does paid sick leave, what is it that the paid sick leave law doesn't do? It seems fairly expansive, but there are areas it doesn't cover. Employers may continue to require reasonable advance notice for employees using paid sick days. And under the law, if it's a foreseeable absence, the employee must give reasonable notice. If the absence is not foreseeable, the standard is that the notice must be given as soon as practicable. Now, that's fairly consistent with the law about the FMLA and CFRA and the employer has. The law doesn't say anything about doctors. And so one reasonable interpretation is this law is not intended to interfere with the employer's right to essentially verify if an employee actually has a valid excuse for being off work and for taking sick leave. San Francisco is a bit more restrictive, and those of you in San Francisco in terms of when you can and cannot. Now, the unexpected consequences of this new law, all good intentions can have downsides, and here the legislature was focused on providing sick pay to employees to make a more productive workforce. At the same time, they gave a gift to the trial lawyers, and what they did was they created in the law a number of remedies for civil lawsuits. And the lawsuits are not just for the failure to provide paid sick leave, it's also for retaliation for an employee using or requesting sick leave. And under the law, they provided the California Labor Commissioner and the Attorney General powers to enforce this law, and that can include administrative actions. There can also be civil collection actions filed under the California Private Attorney General Act. That's referred to commonly as PAGA. And those of you that have encountered PAGA know that it can be a very costly mechanism to defend. And in PAGA actions, essentially an attorney can file a suit on behalf of a number of employees. It could be a couple of employees who are actually named in the lawsuit, but on behalf of the entire workforce, and seek penalties and attorney's fees. And under this law, attorney's fees are available along with reinstatement, back pay, payment of sick days, unlawfully withheld, and a variety of other penalties. So it's very important that in your employment policies that you provide clarifying language about prohibitions against retaliation and reaffirm the rights that they have to seek this sort of leave. Now, let's move to some of the other employment laws that have taken effect. The Fair Employment and Housing Act, as you know, provides anti-discrimination, anti-harassment protections to employees, and that can be on various protected classifications, including race, ethnicity, disability, sexual orientation, et cetera, et cetera. The FEHA was amended this year to include protections not just for job applicants and employees, but also to unpaid interns and a limited duration program providing unpaid work experience. So if you have a intern working there, a volunteer essentially, that you can have someone claiming discrimination. The same goes for harassment. You can have a lawsuit for discrimination or harassment by that unpaid worker. As a side note, anyone that does use interns or volunteers needs to be very careful to avoid wage and hour exposure. And the law is very clear on when an intern, or at least has a standard and a variety of factors that are considered in determining whether an intern is an employee or properly considered an intern, and you look at what type of benefit is provided to that intern and whether regular workers are displaced. So that's something you definitely want to consider. Now, move to the next slide here. Okay, so the other change in the law was that the FEHA was also amended to clarify that national origin discrimination includes possession of a driver's license issued to those unable to submit satisfactory proof of authorized presence in the United States. Now, as many of you know, California has reinstated the privilege of having a driver's license to undocumented individuals, whereas before it had been prohibited. In connection with that change, the legislature has enacted a number of protections to ensure no adverse impact on individuals holding those driver's licenses. And so here, essentially, an employer who takes any adverse action against an employee for having that license, I don't know how an employee would prove that. Can't imagine why the legislature would need to enact anything like this, but it's important to ensure that that nothing's done that would suggest discrimination. And I, quite frankly, don't see this law having much legs. Now, the other change, or another one here, is as you know, in California, employers are required to provide training for supervisor employees on sexual harassment. This is employers with 50 or more employees. And that training requirement now includes training on the prevention of abusive conduct. And abusive conduct is defined as conduct with malice or ill will that a reasonable person would find hostile, offensive, and unrelated to the employee's legitimate business interests. And examples are derogatory remarks, insults, physical conduct that a reasonable person would find threatening. And what's interesting here is there is this requirement to add to the training this sort of anti-bullying component. However, the FEHA has not been amended to provide anti-bullying protections, and I think that was really the intent of some members of the legislature, and they couldn't get the votes to approve that, so therefore they added it as this training component. Many of us that conduct harassment training already have a component. As many of you know, if you have a supervisor that's engaging in abusive conduct, even if that's not motivated by discrimination, it can lead to potential harassment discrimination. Another new law is AB 1897 that adds joint liability for wage violations involving workers that are supplied by staffing agencies. Now, under existing law, there is, under joint employer liability theory, potential exposure for any company that obtains workers through a staffing agency, meaning that if those workers are claiming are not paid their wages, they can claim, based on the degree of control by the business, that the business is a joint employer. Now, that has at least provided an argument for the employer to say, no, we're not the joint employer, and this is the reason why. Now there isn't any argument that can be made. If you do receive workers from a staffing agency, you are considered jointly liable for wage and hour purposes and for workers' comp. And it is very important, given this new law, as it was in the past to some degree, to ensure that your staffing agencies are. And there is an exemption here if you have fewer than 25 workers, or you are supplied 5 or fewer workers by the staffing agency or other labor contractor. This law does not apply, but it is particularly important that you confirm that your staffing agency is paying the proper wages that are due. I have seen quite a bit of litigation over this, where a business will hire an outside agency and they're not complying with the laws. And in some cases, the outside agencies might be providing a good rate because they're cutting corners. and then at the end of the day, it's really the business that's receiving the contracted workers that is on the hook. Okay, so another change. Let's move on to a Cal OSHA amendment. There are two different changes, AB 326 and AB 1634. And the first change, which is relatively minor but was just a question of modernizing reporting requirements, now allows employers to report occupational injuries and illnesses to the Division of Occupational Safety and Health by email, whereas before it was telephone or telegraph. And as many of you may know, Cal OSHA requires that any serious injury or illness be reported within 8 hours of the employer knowing injury or illness. Otherwise, the employer has 5 days to report for other types of injuries or illnesses. The other change to the Cal OSHA statute involves the division's ability to reduce penalties for the abatement of serious violations. And by abatement, that would be correcting a condition that exists. And a serious violation is any realistic probability that death or serious injury could result from the hazard at issue. And essentially, the new law requires that the employer actually correct the violation before the penalties can be reduced, and that's at the initial or subsequent inspection or by a verified statement that's submitted. And there's other changes too also for the petition for reconsideration, and clarifying that just by filing an appeal that will not stay or suspend the requirements to abate. Okay, and so there were also other changes involving various wage penalties. One is there are certain penalties for liquidated damages for minimum. Typically, penalties in California have a 1-year statute, meaning that you can go back 1 year to recover those penalties. The legislature amended the statute to clarify that the statute of limitations for those penalties relate to the action for wages, meaning that it would essentially be a 3 or a 4 year statute of limitations for recovering liquidated damages for minimum wage violations. And the liquidated damages are essentially that the employee would recover the wages due as well as an equal amount, so essentially double what the wages were. The legislature also expanded various remedies for child labor violations, authorizing treble damages, which is essentially a multiplication of the damages that can be recovered, and also increasing the civil penalty to $25,000 to $50,000 for violations involving wage and hour violations for minors aged 12 or younger. Now, another change to the law is the expansion of one of the leave statutes. There is an existing leave statute that provides that employees that have an emergency duty obligations as a volunteer firefighter, reserve peace officer, or emergency rescue personnel may take time off and cannot be retaliated against for taking that time off. This law expands the definition of emergency rescue personnel to include members of disaster medical response teams sponsored or requested by the state. This is a relatively minor change in the law, but you'll want to update your employee handbook to reflect. Another law is AB 2751, and I refer to it as the Conflicting Immigration Obligations Law, and it is frustrating because essentially, this is an attempt by the legislature to undermine the immigration laws federally, and it's really putting employers in a difficult place because although this law cannot interfere with the federal immigration laws, they're doing the best job they can. So essentially, you're allowed to comply and you're required to comply with the federal immigration laws, but if you do anything beyond that, you can be violating California law. And so last year, the legislature prohibited discrimination against employees suspected of being undocumented. This year, the protections were expanded to prohibit an employer from making any threat to file or file a false report with any state or federal governmental. The more significant component, however, is that it prohibits retaliation of employees for updating personal information based on a lawful change of name, social security number change, or federal employment authorization document. And so the issue here is that if an employee provides you a new documentation, new social security number, a name change, has a new federal document, if you scrutinize that document in a way beyond what the federal law requires, you may run afoul of this new California law. So my words of advice are to comply with the letter of the federal immigration laws and be very careful for what you ask for and where you conduct that might be immigration related beyond what federal law requires. Okay, the next new law is AB 802. Now, this also reflects a activist strand of the California legislature in attempting to undermine existing law. And here there has been a wave in California of decisions supporting the right of employers to demand arbitration of employment disputes. And California, the trial lawyers and the unions are none too happy by that. They've had the ear of the California legislature, and on their behalf, the legislature has enacted this new law that tries to undermine the arbitration process. And it'll be interesting to see if this holds up in court after potential challenge. And so what this law does is it basically destroys the confidentiality of the arbitration process, which is a great benefit that we have. The new law requires that the arbitration services like AAA or JAMS publish detailed information about the outcome of private arbitrations. Some of the information they're required to disclose is whether the arbitration is based on a arbitration clause, the name of the party seeking arbitration, the nature of the dispute, the party who's prevailing, the total number of occasions the employer has requested arbitration or demanded arbitration before with his service, the names of the attorneys that have represented them, how the arbitration has resulted, the amount of the claim that was requested and awarded, and the amount of the fee claimed by the arbitrator. And so that's a lot of information that would be out there, and that this is information potentially that could be used by the employee's attorney to somehow skirt the arbitration process or at least undermine it. Okay, and so there's a number of other employment laws that have gone into effect statewide, and these are ones that may be less significant to you, so I will address them briefly, but something to note. One is the legislature has changed the deadline for filing appeals and unemployment benefits claims. It used to be 20 days, now it's 30 days. The legislature has also expanded or applied waiting time penalties to the payment industry. and waiting time penalties, as you may know, are penalties that are recoverable where wages are not paid out on termination. The other change in the law is the new ban the box law that it was enacted in California. It applies only to state contracts involving construction-related services. So those in the construction industry that have contracts with the state would be bound by this. I suspect that this law will be used to potentially expand to all employers at some point in the future, and likely the legislature did not have the votes when this was passed. Another new law is a prohibition on retaliation against employees for receiving public assistance. The legislature also has authorized the California Labor Commissioner to impose waiting time penalties, part of its citation process. Previously, waiting time penalties could be recovered, or presently, in employment actions or in hearings before the Labor Commissioner. These waiting time penalties for failure to pay wages due on termination are now recoverable in the Commissioner's citation process as well. Another significant change, this may be more of a concern in the hospitality industry where you have various service contracts, but the AB 2617 essentially bans arbitration agreements in certain service contract situations. And basically what this law does is there is an existing law that prohibits discrimination or harassment in connection with providing goods or services. And that those prohibitions concern claims based on sex, color, religion, ancestry, national origin, or disability discrimination or harassment. This new law prohibits a company from inserting into one of its service contracts a requirement that vendor, customer agreed to arbitrate any claim for discrimination or harassment existing law. Okay. So let's move over to the minimum wage laws. This has been a really active year on the minimum wage front. This issue has been front and center not just in California but in other states. The minimum wage laws involve, of course, the state that has a state minimum wage of $9, but there are higher minimum wages in various different municipalities. San Francisco just passed a ballot initiative increasing its minimum wage to $12.25 effective May of next year. Similarly, Oakland had a ballot initiative that passed that increased its minimum wage to $12.25 an hour. Berkeley has a minimum wage of $11. The city of Richmond has a minimum wage of $9.60. And then in Los Angeles, there is a citywide generalized minimum wage that's under consideration. There's also the citywide hotel minimum wage ordinance that passed just recently. And that ordinance, for those of you in the hospitality industry, applies to hotels with 50-plus guest rooms within the LA city limits. And that minimum wage is very high, of $15.37. And there are some other related requirements that I will discuss in the next section. Okay, so let's look at some of the significant local employment laws outside of the minimum wage laws. In San Francisco, we have the ban the box law. It's called the Fair Chance Ordinance. I love these names that they attach. It's not seen as so fair for employers. The reason why I'm spending some time on these ordinances is because even if you're not doing business in San Francisco, I think you can expect that statewide there will be something patterned after these laws. There definitely has been a pattern of the state copying the San Francisco laws. And the ban the box, there's been this tremendous trend throughout the country to enact this, which would essentially prohibit an employer from making certain criminal background inquiries of applicants for employment. And the significant change in this law, that this law affected, was that an employer cannot make inquiry into the criminal background of an applicant on the job application or at any time before the initial job interview or before an offer of employment is made. Then once there is an initial interview or a conditional offer of employment, the inquiry needs to be limited. So San Francisco allows you to go back only 7 years. And there are certain exceptions here. This law, as a local ordinance, cannot interfere with state law. And so if you are a healthcare institution where you have to comply with background requirements by Department of Public Health or other agencies, you still will be allowed to comply with those requirements. Unless there's some clear state or federal requirement that you're complying with and conducting the background. In San Francisco, you need to comply with this ordinance. And therefore, San Francisco employers must modify job applications, provide certain notices, and have revised language in their hand. There's also the very new Retail Workers' Rights Ordinance. And we're still evaluating the impact of this ordinance, but this essentially is designed to apply to chain retailers that have really borne the brunt of this new law. And that's defined as any retailer with 11 or more stores. And basically, this ordinance is designed to prevent retailers from hiring part-time workers in lieu of full-time, and requires that the retailer offer available full-time work to existing part-time employees before hiring another worker. There's other intricacies, but I think it's safe to say that we're going to see something like this on a larger scale outside of San Francisco. There's other new local ordinances. There is in Oakland, they passed their own paid sick leave ordinance. This was by the same ballot initiative that increased their minimum wage. There was also a hospitality service charge component, and this also occurred in Los Angeles. And essentially, what this does is it requires that any mandatory surcharge or mandatory gratuity that a hospitality institution receives be distributed in whole to the employees. Under existing law, tips must be provided to employees with certain tip pooling options available, but mandatory surcharges can be divided up between management and employees at management's discretion. That's removing the discretion here. And this is the first time I have seen in California anything like this, and they're occurring both at the same time in Oakland and Los Angeles, suggesting that the industry unions are mobilizing around this issue, and it's something that hospitality employers need to be aware of in terms of fighting further efforts in other jurisdictions. The same type of law was enacted under the citywide hotel minimum wage ordinance in Los Angeles, requiring that automatic surcharges be distributed to employees. It's important to note that, though, that the LA law does not apply to all hospitality employers, but just ones with the threshold of 150 guest rooms. Okay, so the next heading is you mean San Francisco has other employment laws, because there are so many in San Francisco, and many employers are not aware of them. And there is a family-friendly workplace ordinance that requires employers to essentially, in San Francisco, to engage in an interactive process with employees over any request for a predictable or flexible workplace. And it's really a process-driven law that is that doesn't require that the employer actually grant the request, but you have to engage in this process of meeting with the employee and responding. If you don't do so, there can be some significant. Also, of course, the sick pay ordinance in San Francisco. Yes, it's still relevant, surprisingly so, given that the California sick pay law was written not to preempt and restrict local ordinances. There's also the healthcare security ordinance in San Francisco. Despite Obamacare, it is still relevant, and requirements under that law about how much must be contributed per employee, and if you don't meet that threshold, there can be some penalties. And then if employees opt out of the health care, you may still be required to provide other types of benefits. So meaning that if they opt out of the health insurance, you may need to provide a flex plan or a contribution to the city fund. There's also a requirement for commuter benefits in San Francisco, and that requires providing either a flex plan or some for employees for health benefits. Now, if you have any questions, you can input them on the chat line. I do have a couple that were just emailed to me that I'll address now. And then if you have anything further, please just go ahead and type it in now. One question was, how do you calculate the rate of pay when paying out paid time off when the employee earns commissions? Now, that's a frustrating process. So basically, you have an employee who is earning commissions, takes paid time off under California law, and you need to figure out how much you need to pay out for that time taken. Because there's no clear rate of pay given the commissions, what the California sick pay law requires is that you divide the employee's total wages, but that excludes overtime, by the employee's total hours in full pay periods of the prior 90 days of employment. And this is a bit of a frustrating process because it requires that you go back 90 days, do this calculation every time you're about to pay an employee out for paid sick leave. Not a well-written provision by any means. And just to be clear, this is for commissions, not bonuses. Commission under the Labor Code in California is compensation paid to any person for services rendered, the sale of the employer's property or services, and where there's some proportional payment made to the employee for the value of that good or service. Whereas discretionary bonuses, for example, those would not be included in the calculation. You would not have to do a special. There's a similar calculation, too, that you'll need to do if you have employees with different rates of pay. In those circumstances, you'll need to go back and do an averaging using the same 90-day benchmark as would apply for commissions. Now, another question is, although accrual of sick pay under California law begins July 2015, what should employers begin doing on the first of the year? It's true that the accrual entitlement does not begin until July 1st. However, California employers are required to comply with the notice requirements, and that means that they need to provide the wage theft notice July 1st with the additional information about sick leave, and they must also have postings in the workplace, as well as complying with any accrual requirements if they decide for some reason to begin the accrual July 1st. Now, it's important to get a hold of that wage theft notice as amended just recently, as well as the DLSE posting. You can find that on their website. If for some reason you can't find it, you can send me an email and I'll send you the notice. All right, and there was one last question here, which is, what can an employer do to protect itself from liability when it uses a staffing agency? Now, the new California law is clear that there is joint liability for any contract workers that are obtained from staffing agency. And you cannot waive that liability by an agreement, and whether that be with the staffing agency or the issue. But what you can do is you can, and this has been an issue for many companies, a long time, but something that's more of a dire need and interest now, is to ensure that that you are, one, monitoring your staffing agencies, working with respectable agencies, making sure that they're complying with their wage and hour and workers' comp obligations, and two, that you have contracts with these agencies that contain indemnification language that essentially provides that if there is any claim, any liability, that you will that the agency will pay for your legal defense and will cover for any losses. And that is more important than ever. Unless there's any further questions, that will conclude the webinar. I didn't provide you, here's a question slide. Here's my information too. If you have any questions, follow up, you can always email me at asummer@conmaciel.com. Oh, and I do have a question. All right, so Praveen had a question here. Let me answer that. Are violations in sick pay calculation covered by EPLI? Praveen, that's a very good question. Typically, wage and hour claims, such as this one, would not be covered by EPLI insurance. And so that's something to consider in terms of evaluating your risk. What any wage and hour claim, whether it be failure to pay minimum wage, overtime, vacation, things of that nature, I have not seen an EPLI coverage, a policy that actually covers that. And even independent of that, it's really important for wage and hour claims to have clear policies and practices in place. This is an area that has really been exploited by the plaintiffs' bar. And I would say that in the last 10 years, we've had a surge in litigation in this area, and the claims typically can be very costly and provide for the recovery of attorney's fees. Well, thank you all for participating in the webinar. Again, here's my contact information if there are any follow-up questions. And we'll have many more webinars throughout the year. We have a number that are already being scheduled in the next month on a variety of employment-related issues that will be scheduled periodically throughout the next year. Thank you.